Hello everyone, good morning. I am Jemima here from Auckland, New Zealand. Today we will be discussing and giving a brief introduction about the Tenancy Disputes Tribunal here in New Zealand. New Zealand is a country of many migrants reside, and renting an accommodation is one of the most basic requirements. So if one is in a tenanted accommodation, relationships between the tenant and the landlord is inevitable. However, this relationship does cause disputes very often. You would often see landlords having issues with their tenants for non-payment of the agreed rents. And on the other hand, you would also see tenants having issues such as breach of their tenancy agreements where the landlords have failed to provide the necessary amenities. So the Tenancy Tribunal is a body in New Zealand that attempts to solve these disputes rapidly and effectively. To discuss about these tenancy disputes, we have with us Mr. Arunjeev Singh, who is a barrister here in New Zealand with over 15 years of experience and is an expert in tenancy matters. Before we start, if you find this information valuable, please don't forget to like, share and subscribe and leave your valuable comments. So I would like to now introduce you to Mr. Arunjeev Singh.
Thank you, Jemima.
So Mr. Singh, I would like to start off by asking you, could you please tell us about the structure of the Tenancy Tribunal?
Tenancy Tribunal is by nature a small claims tribunal where the disputes between the landlord and tenants of a minor nature, they are resolved by way of mediation, and if not possible, then by way of a determination. So the tribunals are subordinate to district courts, and any appeal against the determination of a tenancy tribunal goes to the district court.
Are the presiding officers in the tribunal called judges?
No, the presiding officers of tenancy tribunal are called referees, and when they address the parties during the investigation meeting, they address by the names, and you can also address referees by name, or you can say sir to a male referee or ma'am to a female referee.
And what is the language in which the hearing takes place?
Right, so the language of communication in the tenancy tribunal is English, and if you are not comfortable or kind of efficient in English language, then you can request the assistance of an interpreter in your own native language, but you need to inform the tenancy tribunal in advance whether you need assistance of an interpreter, and if yes, then what language you would need that assistance to be in.
Alright, and my next question is, what kind of matters does the Tenancy Tribunal bear and what are their limits?
Right, so there is a jurisdiction limit for the tenancy tribunal. The first is the matters must be of normal nature relating to the relationship between a landlord and a tenant, and sometimes between the property management companies and the tenants and the landlords. And if there is a claim of more than $6,000, then the need for a lawyer to act for any party can be seen, and the court can allow the representative to act for the parties in the proceedings.
Right. And well, my final question is, now that we've learned a lot about the Tenancy Tribunal and the matters that can be heard in it, what is the process and how can one approach a Tenancy Tribunal?
Most of the landlords approach the Tenancy Tribunal for eviction of the property, for default by the tenant to pay the arrears of rent, and then the tenants have a claim before the Tenancy Tribunal, most likely relating to breach of the tenancy agreement or failure of the landlord to comply with the obligations under the Residential Tenancies Act, and any particular damages or loss caused to the tenant for the failure of the landlord to maintain and upkeep the property as per the law. And when a party has a grievance against the other party, then a first letter of demand must be raised by the aggrieved party to the opposite party, and a reasonable period should be given to redress or to respond to the letter of demand. And if the other party does not respond or does not remedy the default, then the aggrieved party has right to apply for a claim in the tenancy tribunal. The claim can be filed either on paper or online, and there is a prescribed fees depending on the amount of claim an applicant claims in that application. And once the application is filed, then a notice of hearing shall be sent to both the parties, or if there is any other third party required, like insurance or the property management company, then the notices are issued for the parties to attend the investigation hearing with the referee of the tenancy tribunal. And sometimes these hearings are done on a video platform or in a teleconference, or if there is a need, it can be in person as well.
Right. Thank you very much, Mr. Singh, for that valuable information. And we have come to an end of this episode. But we will be bringing you more regarding the tenancy matters and the disputes in our second episode. So stay tuned, and please, thank you so much for watching. Please don't forget to share, subscribe. Thank you.